The Americans with Disabilities Act, ADA, first passed in 1990 and then amended in 2008. The ADA Amendments Act, or ADAAA, prohibits discrimination based on a person's disability. It is meant to level the playing field for people with disabilities, including those who are dyslexic. The ADAAA, discussed in detail below, is critical in ensuring that dyslexic students receive accommodations on high-stakes tests, such as the SAT, ACT, and examinations for graduate and professional schools. Section 504 of the Rehabilitation Act of 1973, commonly referred to simply as 504, is frequently applied in cases where students may not qualify for an IEP, yet may require accommodations. While a 504 designation may provide a child with accommodations, it does not provide the extensive protections and services for children found eligible for an IEP under IDEA, including interventions for dyslexia. With this as a preface, let's review some of the most important and relevant components of these laws directly applicable to protecting and supporting dyslexic students. Because of its direct relevance to obtaining educational services for children with dyslexia, we begin with one of the most important components of the IDEA, the IEP. The first step in the IEP, Individualized Education Program, process is determining whether the child meets the criteria for disability as defined under the IDEA. In order for a child to demonstrate that she is eligible to receive services under IDEA, she must meet two requirements. She must have a disabling condition, dyslexia, which is included under specific learning disabilities. The impact of the condition, her dyslexia, must create a need for special education services. Once it has been determined that she meets these requirements, the school district must convene a team to develop the child's IEP. The Americans with Disabilities Act, Amendments Act of 2008, ADAAA, is the most important federal law affecting your or your child's ability to obtain accommodations, especially on high-stakes tests. There has been a cosmic shift in the law and the attitude of government agencies responsible for enforcing the law in favor of granting requests for accommodations to bright and academically high-performing dyslexic students. It is important to be aware of what the law says, because it is often in conflict with what testing agencies claim. Over the years after the passage of the original Americans with Disabilities Act, ADA, in 1990, progressively restrictive judicial decisions posed a serious setback to all that had been achieved in gaining civil rights for the disabled, including those who are dyslexic. The dyslexic community owes a huge debt of gratitude to a group of especially caring and committed congressional representatives and senators who crafted the Americans with Disabilities Act, Amendments Act of 2008. The ADAAA made clear Congress's intent in passing the law so that there would be no question when cases came before the courts as to what Congress had in mind. In 2016, the U.S. Department of Justice published an extremely important document that codifies the critical issues Congress sought to effect with the passage of the ADA-AA. Quote, the final regulatory assessment, final rule, amendment of ADA Title II and Title III regulations to implement ADA Amendments Act of 2008. Here are its most important elements. In a change from previous regulations, dyslexia and not learning disability is considered the primary central entity. Throughout, the DOJ refers to dyslexia and other learning disabilities. The term disability is to be interpreted broadly. The primary object of attention in cases brought under the ADA should be whether covered entities have complied with their obligations not to discriminate based on disability. Congress instructed that, quote, the question of whether an individual's impairment is a disability under the ADA should not demand extensive analysis, end quote. Specifically, comparison of an individual's performance of a major life activity to that of most people in the general population usually will not require scientific, medical, or statistical evidence. Types of evidence that are less onerous to collect, such as statements or affidavits of affected individuals, school records, or determinations of disability status under other statutes, should in most cases be considered adequate to establish that an impairment is substantially limiting.